of Dr. McEwen and Mr. Brown will elaborate on these key issues when he speaks shortly. So relying on Mr. Brown's conclusions and evidence, I submit that the RHA overlay isn't appropriate in its entirety, and in the absence of robust evidence confirming that RHA is not concerned with character and amenity values, it is reasonable for this panel, when undertaking its weighting exercise, to conclude that the RHA overlay is likely to go beyond what is necessary to protect heritage as required by Section 6 FRMA. Just turning to Rugby Park specifically, at this stage, it is clear from Mr. Brown's evidence that Council has undertaken a broad brush approach when applying the RHA overlay provisions to Rugby Park, which we say is without merit, and apologies, that's also Mr. Joll's evidence, who supports this conclusion, where he resoundingly concludes that the RMA's purpose is better achieved if the RHA overlay controls are not applied to the park, especially when bearing in mind Mr. Brown's conclusion that Rugby Park is not integral to the RHA. Mr. Joll Mr. Joll maintains his position that the RHA overlay controls should not be applied to Rugby Park after reviewing the summary evidence from Ms. Dixon and listening to Dr. McEwen's presentation yesterday as well. And Mr. Joll will elaborate further on these points shortly.
The question, you looked at two possibilities of relief. The first one being, remove the RHA in its entirety, and then a secondary, if I could put it that way, alternative around the two properties of the park itself.
Yes.
Given what you've said around fundamental omissions or failures around satisfying Section 32 in respect of the RHA per se, how then is the alternative relief of Rugby Park and the two properties, residential properties, justifiable? If it's a fatal flaw in the RHA methodology, how could that alternative relief be supported? Maybe that's a question for you. Yeah. I'm interested if there's a generic criticism, if you like, or omission failing that undermines the RHA for this location in general. If you accept that, how then is it possible to have a reduced area of RHA, i.e. excluding Rugby Park and the two residential properties? Because wouldn't that be flawed fundamentally as well?
I think it would, and obviously we can't predetermine what the panel's decision will be, so we're saying there is a fundamental flaw with the entire RHA. If the panel was to reach a different position on that, then we're also raising significant concerns about the application of that to Rugby Park with specifically. Yeah, so it cuts both ways, doesn't it? If we're of the view that there is a failing that's not able to be remedied, then only one solution sits before us, and that is the removal of the RHA. It's conceivable that it might have wider effect as well, but in relation to this one, if there's components of the Section 32 that are missing that could be remedied, then that might support the alternative relief.
Yes, that is the conclusion that I would reach. Yeah.
Sorry.
No, that's okay.
Could you just remind me where you are now in terms of your summary?
Just covered. Mr. Joll will obviously elaborate further on why those provisions are not appropriate to apply to Rugby Park. And then I was just going to round this section off by submitting that essentially when balancing CRFU's social and economic wellbeing against the proposed restrictions, the application of the RHA overlay over Rugby Park simply cannot be justified and is contrary to Part 2 of the RMA, and also Mr. Smail will elaborate further on how those provisions will impact CRFU's social and economic wellbeing shortly. So then just very quickly, the final points address the matter of scope, but just specifically in relation to isolating and removing Rugby Park and the two residential units from the RHA. should the panel decide this to be the most appropriate recommendation based on the evidence before it. So just as you were alluding to before, the matter of scope is traversed in paragraphs 30 to 33 of my legal submissions. However, like I said, given this has not been raised as a point of concern by any other party, I'll only address it very briefly. And in summary, I submit there is scope provided by the submission of Melissa McFarlane for the panel to accept the submitter's request and pass, with the effect that the RHA overlay is removed from just Rugby Park and or the 2 residential sites. However, once again, I reiterate that CRFU maintains its position, mainly in reliance on Mr Brown's evidence that the entire RHA is inappropriate, and is therefore respectfully submitted that the RHA be rejected in full by the panel as part of its final recommendation on this plan change. And I do have a summary here, apologies, that I can provide to you of this official document. Yeah, summary for summary. Yes. In the matter of trying to cut down the time.
Appreciate that.
All right, so the scope, you're saying that because of the breadth of the original submission.
Yes, we're not enlarging here, and anyone who had obviously could have raised concern with Miss Melissa McFarlane's submission through a further submission in terms of removing the RHA over particular areas. So there is no issue of natural justice if the Commission decided to remove the overlay just from Rugby Park or the 2 residential.
Section 32.
Yes, so setting aside the section 32.
So to be able to reduce the area of
Yes.
Right, where do you want to take us first?
Yeah.
My name's Tony Smail. I'm CEO of Canterbury Rugby. Thank you for the opportunity to speak on the practical implications of imposing the residential heritage area, RHA, over Rugby Park. Canterbury Rugby's been an owner and developer on Rugby Park for 100 years. Our mandate is to foster, encourage and control the game of rugby in Canterbury. We provide social and economic opportunities for all the members and participants in that. Rugby being the country's national game is hugely impactful. We need to continually adapt and change to meet the needs of the people. In operating the headquarters at Rugby Park, we've been able to do that and keep our people's game alive. Fairview was both surprised and concerned to hear that Council had decided to include Rugby Park within the RHA, given the activities that take place at the park. Proposing an additional layer in the form of an RHA over the park will significantly impact our ability to make necessary changes as Canterbury Rugby continues to evolve. With significant cost and uncertainty of obtaining council resource consents, including having to engage expert consultants for any changes required, will affect our future viability to make change. A simple example, we have changing rooms at Rugby Park that are not multi-gender, and our ever-growing female presence isn't fully accommodated. The increased cost of resource consenting will be a barrier and will divert funds away from delivering our core mandate. There are constant changes to our delivery model that will occur in the near and medium term, and we will need to modify our premises to be fit for purpose. Imposing further regulatory compliance on CRFU will affect ourselves. Those groups who use Rugby Park for training and playing, i.e. the Crusaders and Canterbury, and the sport representing 50,000 volunteers involved in the game. In summary, CRFU's position is that applying the RHA rules to Rugby Park is simply unrealistic, unworkable, is cost prohibitive, and will not provide for the community's social and economic needs. Thank you.
Questions and answers. So you're talking about a constant evolution, if you like, if I put it that way, of the facilities to match need over time. Is it foreseeable that that will continue to be able to be made, accommodated in the present park, or will that reach a point where look, the park doesn't serve that purpose anymore? I'm asking you to crystal ball a bit.
No, you'd never say never, but our current vision is that we are at Rugby Park and our community sees that as the home of rugby in Canterbury. We've been operating there for over 50 years that people at the park have been there 100, but there's no vision for us that we're shifting anywhere else. And we'll continue to play both the rugby park and those environments. Yeah.
So it's around 1920.
1929 they started, yeah.
I don't know if any of you earlier, we've had a bit of a conversation with Ms. Dixon around her perhaps rethinking some of the possibility of there being exclusions, if you like, for consideration if the RHA was to apply in a rugby park. And by that I mean particular features or components of the park, either current or future, that might be somehow exempt or excluded from. Now, she hasn't presented anything to us yet in respect of her thinking on that. I wanted her to reflect on it in her own suggestion. So there may be something that comes forward further from that reflection that considers, for example, the possibility of it rather a blanket provision for partial or some exclusions or exemptions. I haven't read that very well, but that's the concept. If that were the case, not directing this to you, directing to you, whether that you would have any thoughts or ideas around if that were the case, what would be those exemptions? I'm sorry to hit you this on the spot, but
yes, I suppose my starting point is that the RHA provisions aren't appropriate on.
accepting that, just exploring possibilities here.
And we're really only now looking, as I understand, with those provisions around alterations, demolitions, and new buildings. There may be something else in there, but they're the sort of key things. I struggle to see how you would carve out those key activities and still retain any merit whatsoever in having an RHA over the park.
So there's a challenge without compromising the integrity of what the RHA proposed on a carve-out basis. There's a risk here. Yeah, sorry, it's an unfair, slightly unfair question, and we don't have that thought very well evolved in our own thinking. It's only come up in conversation this morning.
Yes, and I mean, it's certainly something that I would look at and reflect on, and be happy to focus on it there.
Yeah, it may be one of those things where we receive that information and then we make considerations with its value, and others have an opportunity to equally consider that.
And again, we could do the 30.
We could
do a 32 AA on that and consider it.
We are conscious of the cyclical nature of such engagement processes, which can be problematic. But okay. Sorry, I've deviated.
No,
away.
I was finished.
Question.
And just a couple of clarifications in terms of you say in your paragraph 4 that you were both surprised and concerned to hear that they decided to include it. In the discussions, council prior?
So that was part of the surprise. So we have a letterbox at 6 Melbourne Street. We have a letterbox at 12 Melbourne Street. We have a post office box at Rugby Park. So for the 3 which gets delivered every day, we've had no, and I've been here for 10 years, and we've had no knowledge that the RHA has even come into play across 3 properties. So that's my answer to that question. Absolutely no knowledge until we made some investigation one day and found it. Everything assumption. Yes, yes. Well after. It was within the last 6 months. What was? We found out that there was even an RHA decomposed.
Apologies. You get
I'm the quickest.
summary of John.
So we're going to go to Mr. Brown, are we? Yep. Look, we may come back to you, so you may not be entirely. So, Mr. Brown, can you hear me?
I can, thank you, Mr. Chair.
I'm a little bit aware, I'm aware that you may have been listening in through some of, certainly today, and I don't know about yesterday, so I haven't got easy visibility of who's been on the stream or not. Can you just tell us to start with how much you've observed both today and potentially yesterday?
So I am familiar with, so I've been listening in earlier today, probably about the last hour or so. I've heard a couple of the speakers before us. I have to apologise. I'm a little bit under the weather, so if I sound a bit croaky and so on, my apologies. And then I'm aware of Dr. McEwen's presentation yesterday and some summary facts from that, and I've also reviewed the summary statement of Miss Dixon as well in response. So that's where I am.
Okay. That's helpful. Just feel free, if we're asking you questions on material that you haven't yet had the opportunity to consider, and we've assumed wrongly that you have, just feel free to tell us that.
Sure,
we may not
absolutely.
that situation, but I just having not had you present and not been aware of what you've observed or read or not, we potentially stray into areas where we put you at a disadvantage. So I don't want to do that.
Thank you, Mr. Chair. That's appreciated. So
we have a written summary. Are you going to take us through that? Appreciating you are under the weather. Do you want to read that out or take us through it, the high points? How do you want to approach that?
Yes, if you don't mind, if you have it in front of you, sir, what I might do is just, given the time frame and my condition, take you through the high points if you'd like.
Yes.
So, and then take questions on that.
Sorry, just 1 minute.
Are you happy to have questions while you're going through your summary of the summary as well?
Oh, absolutely, sir. Yes, that would be fine. Yeah. Okay.
Right. Be reassured that we will read it. Obviously, we'll take that time as with all the material. So don't assume that we'll just listen to what you say and disregard the rest.
No, that's appreciated. Thank you. So just for the record, my name is John Edward Brown. I'm the director at Plan Heritage Limited, which is an independent heritage planning consultancy. And I prepared my evidence dated the 10th of June 25. My qualifications and experience are outlined in paragraphs 1 to 5 of that evidence. I should also note that previously I was involved in Plan Change 14, providing evidence on behalf of Kāinga Ora, which also looked at aspects of the residential heritage areas and provisions associated and their relationship to their character areas. As you will have heard from Mr. Chidgey, my evidence is concerned with the notion that I feel that there's a risk here that character area, and there is a defined character area in the existing plan, I acknowledge that. But my concern here is that a character area aspect in terms of amenity is, from a Section 7 perspective of the RMA, is potentially being conflated into a Section 6 matter, being historic heritage. The key issues I have around that is that, in particular, in relation to the sports fields, Rugby Park, and the recreational field of Malvern Park, there doesn't seem to me to be a strong cause and effect link between those elements and the 1923 subdivision that would warrant them being seen overall as an area of significance that should be protected as a matter of national importance. My thought around that is really to do with the way in which and both Ms. Dixon and Dr. McEwen use this expression, the historical lens has been applied to elevate that area really relies on aspects of cultural value, context, and social value, which I don't think have been sufficiently well expressed in the evaluation material to provide that justification. I would say that I am entirely supportive of the methodology that links back to the regional heritage evaluation process, and that is a matter of record from the previous hearing as well. So it's not a question of the general principle. I'm supportive of the general principle of heritage areas. In this position, I'm struggling to see why the fact that the church property trustees divested land as part of what seems to be really a land banking operation from their point of view. They've divested land to provide funds for their core activities, which don't occur on these sites, other than maybe the church at the bottom end there. But they don't occur on these sites, and so I find that relationship is not particularly strong in terms of a significance. The other aspect of that is that there doesn't seem to be a great deal of evidential material supporting cultural association or social association. The focus rather seems to be on the architectural significance of the bungalows replacing, and there's quite a strong effusive statement from Dr. McEwen on the record forms, effusively, the triumph of the bungalow over the villa as a form of suburban living. Now that's well and good, but I fail to see how the triumph of the bungalow as a form of urban living relates to anything that's on the two park sites, for example. So that's really where I sit. I have set out a bit more detail in the summary statement, but following on from that, with respect to the residential properties at 6 and 12 Malvern Street, I do acknowledge that they are bungalow forms, and they form part of that character. My feeling is that they both show signs of modification over time, and question whether, if they were to be retained in an RHA, whether they might be seen as defining, but rather they're maybe more appropriately seen as contributing based on the authenticity of their form. And then subsequent to that, were the park areas to be retained, I fail to see how they would be deemed defining when the focus of the area is, to my mind, quite clearly on the suburban residential form. And that's kind of it from me in terms of the statement. So I'll be happy to take any questions, sir.
Thank you, Mr. Brown. There may well be. Just give us a moment.
Just one really. It arises from the discussions yesterday with Dr. McEwen in terms of the church properties trust, and you would have heard those discussions about basically the trustees going into the council and saying, well, instead of having little pocket parks all around the place, because they had so much land that they were developing, we'll have this, we'll offer this big park here, which has become in essence two parks, but that big area of land. Now, is that a reasonably significant connection, do you think, between the park and the historic subdivision?
No. So I think it's a broader connection, and I think you hit upon it there. The trustees had lots of property all over the place, and this is just seen as a way of conveniently dealing with, I suppose, from their point of view, an element of social give back, perhaps, or perhaps it was greasing the wheels for the subdivisions. Who knows of the politics of the time? But it relates to their wider ownership property boundaries, which aren't defined within this RHA. So for me, and there are sites on neighbouring streets and so on that are subdivided around the same time, but they're not included, but they all refer back to park in terms of parts of their setting. So why is it specifically, and this is my issue, why is it specifically in relation to the 1923 subdivision that these parcels should form something particularly significant to that?
So sorry, so just to get that clear in my mind, it's not, you're not contesting the relationship the trust had with the creating, if you like, of the park land.
They owned,
yes.
yeah, sorry, sir, to be clear, they owned the land, they divested it.
Yeah.
The deposited plans that Dr. McEwen refers to and that I've included also in my evidence demonstrate that divestment, but it doesn't relate to the core purpose of the church. So I think that coincidental relationship doesn't, for me, provide a strong cultural driver for the land to be included in an RHA that really is focused on a built form of bungalows.
Your reference then to the core purpose of the church, what was that?
Well, the mission of the church, the Anglican Church, is the church, isn't it? So, and there's a quote from Dr. McEwen's report where I can't remember exactly what page it is now off the top of my head, but the referral is that the land was divested in order to fund the church's activities. So, and this is quite common practice from my, as I understand from previous work I've had with the Anglican Church as clients, they had large land holdings all over the place, and at points they divested parts of those land earnings to fund church building activities and that sort of thing.
Just hypothetically, if there was thought being given to bringing the boundary of the RHA back to Melbourne Street, for example, thus excluding the parkland, you've talked about what I'd characterise in your words as a tenuous relationship there.
Yes.
What would your view be on the validity of the RHA remaining, but in the absence of those park areas being included? Setting aside 612, so not including that, but just in relation to the park contribution. What's your thoughts on the validity or integrity of the RHA in that scenario?
So I think the question is, what's a defensible boundary of a reduced RHA? Is in this context?
Well, I'm only interested in that northern boundary. I'm not asking the question in relation to others because they're not in contest. So
right, yes, sure.
Yeah, sorry, it's that northern boundary.
Yeah, look, were it to be reduced and retained, then the subdivision boundary of 1923 forms a natural point of consideration. My view of it, however, is that I'm not entirely convinced, to be honest, that the character aspects of the bungalows are so significant that they then merit protection in their own right as an area for Section 6, noting, of course, that they are largely already included in the character overlay, which is absolutely fine from my point of view.
Helpfully, you've raised Section 6 because I'm interested in your professional view on how we should consider Section 6F. So yeah. What is your interpretation of the scope around significance of items, areas, features, whatever they may be from a heritage perspective?
Yes.
In the text of Section 6F, is it any and all, or is there some qualifier under Section 6F to be limiting on what heritage or historic heritage values must be protected for an appropriate subdivision, etc.?
Well, 6S, as you know, includes sites. It includes archaeological sites. It includes cultural sites, and it also includes for areas. So I have no issue with areas being defined.
Yeah.
Ordinarily, they might be defined where there are already a concentration of individually scheduled places that demonstrate in depth and time the qualities of that place. Can you apply it to a particular point in time with the historical lens as is proposed by Dr. McEwen to this one typology? I mean, it has been done, but I think the justification to do that, bearing in mind the sort of risk of not doing it, if you like, what's the heritage benefit that arises from it, and what are you trying to protect? So I think from my perspective, if there were stronger historical links, for example, a typical example might be where people of national importance have lived in one or more of the dwellings. So that type of connection can be quite strong. In terms of events, whether there's been a significant historical event that has occurred in that location, is it the first of a typology? In the case of social housing, the first state house is one building that you would schedule, but also potentially the first state house development might be an area. So as in Hamilton. So what is the nature of that typology? Do they then exhibit these extra qualities that rise it above and beyond neighbouring streets?
Yeah, so I'm hearing what you're saying. What I'm really trying to tease out from you is, does the level of significance have to be at a national level in order?
Oh, I see. No, it can be highly significant at the local level, but it needs to be of a bar above something that might be seen as a sort of moderately interesting or moderately significant. And I think the reason for that is because it does put constraints on owners. It puts on multiple owners, and in this case, on probably over 100 owners. So you need to have a high bar to justify that qualification. I mean, the statements themselves probably could be a bit stronger in terms of demonstrating that bar if you were to accept the RHA. So the idea that, is this the only surviving bungalow? I understand, of course, that Christchurch has had a lot of impact in recent years, but it's that kind of question. Is this the only surviving bungalow suburb, or is it the earliest surviving bungalow suburb? Those things will give you a sense of that depth of quality over and above a standard typology.
Thank you. Just there are some more. Just be with us. How are you bearing up? You're okay?
I've got a little bit of a throbbing head, but I've got some lemsip and some fisherman's friends, so I'm good for probably another 10-15 minutes.
We'll not run you into the grave, but we'll do it. So, Jill.
Yeah, and I'll keep it as short as I can. Mr. Brown, one of your main criticisms on the RHAs is that you see that character and amenity are conflated with historic heritage. We have heard yesterday from Dr. McEwen and this morning from Ms. Dixon a explanation for us on how they see the separation of character and heritage. And we've heard that the character is predominantly a visual element, whereas the historic heritage has a lot of intangible layers and has probably parts of character, but is actually layered with extras on top. How do you see the differences between character and heritage in that respect?
I understand the the desire to form a sort of definition of the two based on that process. So character areas, if you like, usually come out of a period of development of a given time, and they usually do reflect that particular given time. But that given time can be quite extensive. It might be 40 years as opposed to 10 years. And equally, the same could apply to a heritage area. It might be, to give an example of an immediate time frame, a heritage area might define the landscape of a very important battle, which may have occurred over 1 or 2 days. So I don't think that's necessarily a hard and fast rule. This comes to the notion of the historical lens, and really I think that's a question of how much time and effort you put into understanding or investigating a place, I suppose. The issue that I have here is that the statements that drive to the intangible components, the non-visible components, if you like, for the heritage areas, is that they're quite broad, and I don't find them to be strongly supported by evidential material. So I think the notion of that this represents a point in time sort of lifestyle of various people living in the area is not strongly supported by the evaluation material, where they've just referred to 1 or 2 owners out of 100 properties without any other sense of their time frames there, or how long they lived there, or any of that kind of aspect. So what I'm saying is, while I accept that there's ideas around communities that are formed through the assessment of social values, for example, I haven't seen a strong movement by the community itself as to the supporting the overlay in this location, which is quite different to a number of other plan changes that I've been involved with, Hamilton being one, where the Temple Meads area was strongly supported, and there was a lot of community interest, and that's recorded over time in newspapers and things like that. And in the far north, I've just been looking at heritage areas there on behalf of the council, and similarly there was very strong submissions on extending heritage areas where they, for example, at Te Wamati, where it's one of the earliest pastoral farming landscapes in the country. So that for me gives a measure of the strength of that social and community association with a place, over and above a statement to say it's representative of. And we have statements saying it's representative of, but then you could equally apply those statements a street over.
So the examples that you just brought up, as far as I understand, they are all nationally important sites or areas.
Mm-hmm.
Temple View, the only Temple View or the only area of that type in New Zealand. And I can certainly understand the high bar there. Are you telling us that it needs to be at least that significant, that underlying historical lens, to be considered as a heritage area?
So the examples I've given are just ones that people may know. The application of the method determines whether it is of high significance or not, and then it also determines whether it was locally of high significance, regionally or nationally. And you can have items of local high significance that they don't have to be nationally significant.
Thanks very much for those clarifications. That's just for me.
Thank you, Mr. Brown. And you've done well.
Thank you.
I hope you recover, and I hope we haven't added to your misery too much this afternoon. You've been very helpful.
Thank you.
Joll, we're going to go then? Yeah. Just conscious of time and tell you, I know I'm not pushing you, but in terms of the afternoon break, we probably will have a split break after this, Joll, but it'll be a short one. I won't be really not track with you.
Hello again. For those that went in the room this morning, my name is Tim Joll. I'm a partner as consultants in the qualifications and experience are outlined in paragraphs 1 to 5 of my evidence. My evidence specifically addresses the planning merits of including Rugby Park within the Snoep residential area. And I consider the key questions in relation to the RHAs are, is the Section 32 evaluation suitably robust? Is the methodology for assessing RHAs appropriate, and do they meet the requirements of Section 6 of the RMA? And are the RHA provisions appropriate for, so it says Rugby Park, and it should be Rugby Park. Turning to the first question, is the Section 32 evaluation suitably robust? I note that the robustness of the Section 32 report has previously been considered and dismissed by the Independent Hearings Panel. In their recommendations specifically on RHAs, as proposed in Plan Change 14, the panel made the following comments. The panel recommends that the RHA and interface overlay, as proposed in PC 14, should not proceed as a qualifying matter for the following reasons. C, that the merits of the proposed provisions, even if they were justified on grounds of scope under an IPI, which they are not appropriate in the context of the requirements of RMA Section 32 evaluation. The panel also recorded the following concerns. We more fundamentally disagree with the Council's position that the areas to which RHAs would be applied constitute historic heritage in the first instance. In seeking to identify areas as RHA, alongside in some cases interface overlays, we consider, notwithstanding Ms Dixon's assertion to the contrary, the Council has conflated what are at most Section 7C amenity values to the level of Section 6F historic heritage without significant foundation. More specifically, when considering the appropriateness of the additional provisions the Council is seeking to reduce to Rugby Park, Ms Dixon acknowledges in paragraph 28 of her final summary, I agree that the PC 13 Section 32 report does not include any reference to the costs and benefits of moving large open spaces in an RHA. This is primarily because it should be valid to include these spaces in RHAs based on the advice from Dr. McEwen. That in itself is not a Section 32 test. Section 32 requires new proposals to be examined for their appropriateness in achieving the purpose of the RMA. The effects of new policies and rules on the community, the economy, and the environmental need to be clearly identified and assessed as part of this examination. With specific reference to Rugby Park, I consider that the Section 32 report fails to provide any allocation of costs and benefits of applying an RHA over open space zones. Now, I understand Ms Dixon considers that there are separate Section 32s in play for Plan Change 14 and Plan Change 13. What I would point out is that a lot of the evidence, and I can direct you to a number of specific examples in council officers' evidence for Plan Change 14, including Ms Dixon's cross-reference back to the Section 32 for Plan Change 13. So in my opinion, it was a live matter and a matter that the IHP panel considered.
Fortunately, for a moment, just for clarification, paragraph, 3. It's quoted there, if you like, from the panel around RHA and the interface overlay as proposed. Not appropriate. There's a combination of things in there. There's the RHA and the interface, so we're not dealing with interface overlays.
No.
So how valid is that conclusion, do you think?
Well, I think it is still valid because it couples both the interface and the RHAs. It's saying that both together or individually or together, they lack merit.
Is that what you say?
That's what I think it's being said, yeah.
Does that get us any?
Well, I think it does. The panel recommends that the RHA and interface overlay should not proceed as qualifying matter for the following reason. So it's both the RHA and the interface overlay.
Yes, but what's the failing in the Section 32? Is it a combination of the two, Or is it one or the other? I guess is my question. I don't know the answer to that.
Well, there was separate 32 analysis done for both the RHA and for the interface, and they've just coupled that they're both deficient.
Yeah, sorry, I'm not trying to trip you up here. I just haven't read that in context of the decision to understand whether there's more meaning that I'm missing.
From my perspective, I think this comes back to some of the frustration I've heard in the community about hasn't these matters already been addressed. But coming back to your point, sir, we are where we are, and perhaps, well, there are RHP recommendations out there, but for your purposes, you can. There's a section 32 in relation to plan change 13 that can be assessed on its own, and I still think it's deficient.
Yeah, look, I understand that point. Yeah.
Okay, so you're down to 5, you're up to 6.
8.
Yeah,
sorry. So is the methodology for identifying and assessing RHA appropriate? I agree with the concerns raised by Mr. John Brown regarding the inappropriateness of the methodology selected and to assess Rugby Park, which is within the open space metropolitan facility zone under the operative district plan. I also consider, based on the conclusions reached by Mr. Brown, that Rugby Park is not integral to the history and significance of the RHA and should therefore be removed.
Have you heard the explanation?
I have, yes.
You're of the same view.
I'm of the same view. And looking at this from a purely planning lens and not trying to apply any heritage hat that I don't have, when I look at the individual site record form for Melbourne Park, which I understand has now been updated to separate the two properties, but notwithstanding that, there is no rating of any of the individual buildings within that site. And if I turn over, I know Mr. Brown referenced a statement, the triangle of the homework, that comes from the individual site record form for the park. And it comes under the architectural and aesthetic significance. And the only statement is that bungalow style housing in the area illustrates the triumph of the bungalow over the villa for middle class housing in the early 20th century. That doesn't apply to any buildings on Melbourne Park, Rugby Park, in my opinion, as a planning lens. And similarly, when I go down to technological and craftsmanship significance, it states, and this is, I'm sorry to keep going on about, it's an individual site record form for the park. The houses exhibit craftsmanship values typical of the period in which they were built. So houses on the park. Yeah. Anyway, I shall more about.
Okay, that's fine.
From a planning perspective, I also note that the provisions relate to defining contributory, neutral and intrusive buildings. Yet, in reviewing the individual site record form for Rugby Park, there is no commentary on the status of individual buildings. The record for Rugby Park, Melbourne Park, is simply that it is defining that the activity status for works to buildings in an art area varies considerably depending on the rating of those buildings. I consider a robust individual site assessment of the individual buildings on that site should have been included in the site record form as part of the initial Section 32 assessment. The implications of this is that you have elements like the 2.4 metre high corrugated iron fence that require resource consent as a defining building to be removed. And if you take that a step further and you look at the provisions that apply, because it's a defining building, there is no specific non-notification clause for the removal of a 2.4 metre high corrugated iron fence. So I just don't think any consideration has been given to how these provisions would apply in the case of Rugby Park in particular and the buildings that exist on that site. I sort of jumped ahead of myself a little bit, and I talked about the sanitary issue with regard to in paragraph 11. Now, just before I finish up, there's a couple of questions that I think were posed earlier in the day by the panel. One of those was around the amount of built form on the site, of the Rugby Park.
Yeah, I think I said in relation to coverage, wasn't
Yes.
it?
I don't have an extremely accurate figure, but based on calculations of aerial photos, I have the footprint of all buildings at about 3,400 square metres, which equates to about 12.8% of the 26,583 square metre site.
So above that 10% was
Above that 10%, yeah.
existing.
And if I may also just coming back to the question around, could we carve out some provisions for Rugby Park and things? If you were to reassess or undertake any assessment of those buildings and determine that they were neutral or intrusive, then the three sort of rule triggers around alterations to buildings or demolition of those buildings would disappear. So that would leave you just with consideration of new buildings as they would apply to an RHA. And again, I think there's an issue here where the build form standards for a metropolitan open space such as this are significantly different to a heritage area for quite obvious reasons. So in this case, you have a 10-metre road boundary setback, you have a 10-metre internal boundary setback. So there's already provisions in play, that built form provisions that are quite separate and quite different to what the provisions in the RHA may be seeking to achieve. And I think one of the questions you asked is how, and correct me if I'm wrong, sir, but how much is the park already sort of pushing the bounds of what the built form may have been, or?
No. What I was trying to get a gauge on is how restrictive the regime under the open space zoning might be already. And then part of that might be determined by the degree to which buildings push the envelope or exceed them, as you've said, in coverage. So what is the constraining influence that already exists on the operation now, accepting that they are around a different motivation, not heritage related.
Yes.
But if you're talking about a position on a landowner, what are they currently faced with versus what would be the additional, if at all, constraint imposed by the RHA? That was
Okay.
simple inquiry.
Yes. So it is those three key things: any alterations to buildings, any demolition, or any new buildings. And we end up, and I touch on this, and I think it's more a strictly technical assessment, but things like rugby posts would meet the definition of a building. They're open, if you go to a building, it's over 2 metres in height. And I don't think anyone's suggesting that it's a good outcome for a rugby club to have to get a resource consent to bring down goal posts, rugby posts, and put them back up. And if people were to argue there's existing use rights there and things, and that just opens up another can of worms around, if the posts were to stay up an extra week a year or never come down, do your existing use rights lapse and things. So I've given some thought to these implications. And
in fairness to Ms. Dixon, I think those are the sorts of potentials that are sitting in her mind as to whether that was, both what the practical effect would be, but also the necessity to control those things in respect of the values that we're trying to be regulated here, which relate to heritage, for example.
yes.
Any other questions?
Yes.
No, I'm just as a non-planner. Is the question you're posing here, is the methodology for identifying and assessing RHA appropriate? Are you defining that particularly for Rugby Park? Because otherwise I would wonder if we had scope to look at that at all, because we are not talking about methodology. It was plain change 14.
I am, yes, probably referencing back to the evidence of Mr. Brown, and then in terms of Rugby Park, part of that methodology for me is individual site record form, and so that's what I was more really trying to highlight there.
Thank you.
All right. How are we doing?
You run over time.
let's have a break, but let's have 10 minutes only. Apologies for those that are patiently waiting. But it's, I definitely need a break. Let's have 10 minutes and we'll reconvene. Whatever that is. Just after 10. Thank you.
Thank you.
Thank you very much.
We've got some.
Right. I wonder if you want to have a conversation, maybe out there. Maybe not. Let's get a
Yeah,
conversation.
I'm very sorry we're stopping.
No, that's fine. Otherwise, just outside the room. It's helpful. Thank you.
Right, Commissioners, sorry for interrupting. So we get we're in a rush. Two housekeeping matters. First one is that just having supplementary evidence from Mr. Stanley, which is the one you asked for this morning,
thank you.
which records his opinion on what he heard from Mr. Harrison yesterday.
Are we finished? Thank you. Thanks.
And second housekeeping matter, this will be relevant when the Civic Trust are giving their evidence. I understand from emails that I saw this morning that Jocelyn, sorry, I don't recall Jocelyn's surname, but I understand from those emails that she was going to be seeking leave to present her own submission to you as an individual, rather than as a member of the Civic Trust. So I just thought you might want to clarify the capacity within which she's proposing to make a submission to you.
That's you. So you want to present to us on behalf of the Civic Trust or in association with what the Civic Trust is saying, or not, or independently? Are you a submitter independently of the trust? Have you made a submission?
Yeah.
No. Have you made a submission on the plan change itself originally? Did you make a further submission? We've got a problem.
I'm sorry.
Not a problem for you, a problem for us. We're not entitled to hear you in relation to any other than what you've made a submission on if you have. You haven't.
Just on Dewsbury.
That's fine, but you're only entitled to speak to the hearing if you've made a submission or a further submission of the plan change itself. And you haven't, as I understand it. Is that correct?
No, that's why I rang the Heritage Committee this morning and said, you know, why hadn't I been informed? And they said to me, come down at 1:45 and you can be the third person meeting. So I wrote up my thing.
Part of the Civic Trust.
On behalf, so more than happy for you to speak as a member of the Civic Trust or at their appointment if you want to do that. I don't know what the trust view is on that. But all I'm saying is unless the trust invite you to submit in relation to their submission, then we can't hear from you. That's a matter for you to determine. Maybe you want to have that conversation out of the room. I don't know, but let me know what you want. Right. Thanks. Is that the point you were? Yeah. I don't want to disadvantage you. It's just that we're bound by certain things that we can and can't do. Oh, it's full.
Sorry, I was just reading the names on the bottom of the screen. Are they people that are?
It's a live stream, so there's an audience out there that we don't know of, other than the signals along the bottom of the screen. But right, apologies for that.
That's
We're in
okay.
your hands. We've got this, but you're not going to speak to it. You're just going to talk to us. Is that right?
I think so, yeah.
Happy for the door to be opened when you've had the conversation.
That's it, actually.
Thanks.
Okay. So my name is Susan Wall and I oppose the proposed new residential heritage areas and all associated rules and regulations, in particular Church Property Trustees North Slemint, RH3. I've owned and lived at 24 Carrington Street since September 2005, almost 20 years. I've lived in Christchurch for most of my life and I love this. Here by myself today, as I don't have the money for resources such as an RMA lawyer or a planner to assist or guide me through the submission process. Like most people I've spoken to on this subject, I have no knowledge of the RMA and little knowledge of council procedure. I'm here today because I live in an earthquake-damaged house at 24 Carrington Street, St Albans, which I would like to demolish and rebuild. But I can't do that because the council have imposed changes on my area that make this extremely difficult, if not impossible. My home was significantly damaged in the earthquakes, and it wasn't until 2017 that my insurer settled my claim after 3 attempts over 5 years. I believed it would have been a rebuild, but I ran out of steam. I couldn't fight any longer, so I settled a full and final settlement, just so that I could get on with my life. My home is on TC3 land and an IFP, I beg your pardon, zone. So I want to build a solid, long-lasting, healthy family home in keeping with the character of the area for life in the 21st century and beyond. I started the rebuild process back in 2018 and was disillusioned by the pre-application meeting with the council, and I put my plans on hold until I could work out the best way forward. This meeting made me realise that I would need an architect and a planner, a lot of additional expense, and not just the architectural design service that was employed by my chosen building company. I'd intended to pick up where I left off much sooner, but then COVID hit. Life was turned upside down for all of us. And I didn't get back to it until early 2023. Around this time, I'd been inspired by the new dwellings that had been built in that area since the earthquakes and how well they fit into our character area. The new homes motivated me to restart the rebuild of my new home back in March 2023. Late in March that year, after having a consultation with an architect, I phoned the council to ask a few questions about boundaries and setbacks in preparation for the planning of my home. I was told that I may not be allowed to demolish and rebuild. I was told that there had just been a plan change in my area, and the Church Property Trustees North St Albans subdivision, they called it, which I've never heard before, is now a residential heritage area with immediate legal. This meant I'd need a resource consent to demolish, a step not required under the character area overlay. The council person followed up with an email advising me that my house was classified as primary. So I was absolutely shocked by this information and asked why I'd never heard of it, why I was not told, and the council said I'd received a letter. I never received a letter from the council advising that residential heritage designation had been added on top of character area overlay, or that it was even in the pipeline. I'd have expected that someone from the council would have contacted me and all property owners directly to advise us of the additional designation and all the changes involved and how they'll affect us well before this. If I'd have known about this RHA designation was coming, I would have demolished my home and started my rebuild well before March 23. The council person suggested that I have my say. It could make a difference, she said. So I clicked the have my say button and I couldn't understand any of it. Couldn't find my way to exactly what changes had taken place and how that would affect me. And I had many attempts to navigate my way through, but I found it confusing, impossible actually. So I missed my opportunity to make a submission. I was then advised to make a further submission once that avenue was open, and I spent a lot of time on many occasions during that short window, I think it was about 10 days, 10 working days, trying to work out how to make a further submission. I rang Jan West. I went to the council twice to get help. The first time was to ask for a paper copy of all submissions because I actually thought that was in the very big document. That wasn't possible. The second time I wanted paper forms to complete a further submission because I thought that this would be easier for me. The staff in the department that I required had all gone home early that day, or they'd taken the day off, so there was no one there that could help me. So I was told that paper forms were not available, so I asked for a form to be emailed, and that couldn't happen either. Just last week, actually, I came across a document online that gave a brief overview of the proposed changes. It was dated 3rd of March 23, and it had a paper submission form. It had a submission form on the back with instructions, and if I had been able to have that before the cut-off date, I would have been able to. So I still keep going, wouldn't you?
Just clarify for me, did you actually end up making a submission on plan change 13 or a further submission or not?
Yes.
Yeah, sorry.
That's okay.
I was nervous there for a moment. I thought you were taking me on a journey that find ourselves in a similar position. I just had to reverse. So, okay, fine.
I did.
Were there several? I'm just trying to.
Yes.
Yeah, okay.
They don't make much sense, but they helped me get here.
No.
After that last visit to the council on the 13th of July 23, I was totally panicked, running out of time. only a few days to go, and it was just really, really difficult. Anyway, by some miracle, I did manage to do enough to get me the opportunity to be heard back in November and to be here today. The whole process of submitting is difficult and so incredibly complicated that I expect that most people wouldn't even try. And I would be interested to know how many individuals who own properties in the new proposed RHAs made submissions or further submissions on this plan change. So getting back to my story, I then engaged a planner in April 23 to make an application for resource consent to demolish, and this took a very long time because of the plan change. I was invoiced $1,640 by the council for information they gave my planner in a telephone application meeting, which I feel this information should have been supplied without charge, as it was needed to prepare the application due to the new RHA plan change. The application was finally completed and lodged July 23. And after paying a $2,000 fee, I was allocated a planner on the 15th of August, and he has since come back and said that it should be notified, and in order to progress, I would need to pay a $10,000 fee so that they can start the notification process. So at that time, I put my application on hold, and it's been on hold since. I did this because I was hopeful that the change of government or the IHP process, the one that's been and gone, may recommend that the council drop new RHAs from or grant my application without the long, difficult and costly process of notification. Also, I don't have $10,000 plus to fund notification process with no guarantee that my application will be granted. I keep hearing in the media that councils are making the consent process easier and less expensive, but in my experience, that's just not true. In preparation for the hearing in 23, I tried to read some of the other that was a no-go because it's just too complicated. And I did read as much information as I could find online, but I couldn't locate much. And again, it was difficult to read and understand. But many of us, in Christchurch, all over, we're aware that there was a plan change coming. And it was the MDRS stuff that had been in the media. But residents in my area, we've always known that character overlay rules and restrictions don't allow inappropriate subdivision, use and development, infill housing, high density or multi-unit developments in our streets. As I spoke with neighbours around that time, I became increasingly aware that I was not the only one who did not know that RHA designation had come, and I didn't know anything about it. I wasn't alone. So I did a small survey, and I did the survey back in November 23. Our area is fairly stable, so people stay a long time. So I just wanted to note that 82% of people had been there over 5 years at that time, and 62% over 10 years, with some people having been there 40 years. So 49 of the 60 owners had absolutely no idea that we had a new residential heritage area status with immediate effect. 9 did, and of those 9, 4 of them work in areas associated with the council or building industry, and 4 of them thought they'd just seen a headline somewhere. 52 of the owners out of the 60 did not know it was going to happen before the RHA designation came into effect. 5 did, but again, 4 of those work in the building industry and the council. 56 out of the 60 did not know what changes were involved and how they were going to affect them as property owners. 57 out of 60 owners did not know the RHA designation is effectively another set of rules and restrictions on top of the character area overlay rules. 59 owners think that the council should have contacted them and all property owners directly to communicate and discuss changes and how they will affect property owners before even considering making changes in our areas. 57 of the 60 think that the council should not have the power to make changes such as this with immediate effect, having not consulted directly or appropriately with affected property owners at the discussion phase. And finally, 59 out of the 60 owners think that we should retain the character area overlay status. And the one that's missing there lives in Rutland Street, and that side of Rutland Street is just going to be RFA. It doesn't have character.
Combination of the two.
Mhm. So, in summary, most of the 60 residents I surveyed in my area did not know our area was RHA with immediate effect. They did not know what RHA meant. They didn't know what it involves or how it will affect them in the future. And I guess now I can add another one because the CR didn't know either. So I got a lot of comments on the way around, and I did want to read some of them out, if you don't mind. One person said, I'm unhappy about the new RHA. I didn't know it had happened or it was coming, and I'd like more freedom to be a bit more creative. Character area overlay, a great concept and appropriate for our area. I do not believe the council should have the power to make changes with immediate effect. The proposed changes should have gone through a hearings process first and submissions heard before having legal effect. Character area overlay. I believe that these rules are appropriate to retain the character, residential density and built form of our area. All of the houses in our area would have to be rebuilt at some stage, as many have significant deterioration, EQ damage, and after many years of absorbing the damp, many are not in good shape. They were not built with permanent materials either. I'll leave you to read the rest of them. So, in July 2024, I felt cautiously optimistic when the IHP recommendations report was released, and I was under the impression that that panel had recommended that RHAs be dropped from the new district plan, but it seems council don't have to accept recommendations made by the panel of experts. And it's been 2 years since I applied for the resource consent to demolish my earthquake damaged home, and I'm no further ahead. So that's sort of about where I got to with my 2023 submission. And so for today, for coming along today, I read as much as I could. I read and reread the 42A report dated the 28th of March 25. Big report, and I couldn't take it all in, but there's things I want to note about it, and I think there'll be a lot of people, if they read it, with the same. I get the impression that the council is using its own new rules to justify the new rules. For example, it's the council that categorised our homes as defining and contributory. It's the council that decided how many in each category. 65% of homes in our area are defining. It's the council that has chosen the base percentage in each category in order to fit the council's criteria for a residential designation, a residential heritage designation. As I read through submissions, it seems to me that if your submission does not agree with council, then it's rejected, using the new rules as justification for this rejection. In 6.1.19, it says that council have no interest in controlling the demolition of buildings that do not contribute to the heritage values of the area. So I just wondered, does that mean that if you're lucky enough that council did not categorise your home as defining or contributory, then you may demolish your home whenever it suits you? These are all just questions I came up with along the way, and things that I found difficult to understand and ambiguous. The author of that 42A states, I do not think it appropriate to remove the need for demolition consents, as this would provide free rein for people to remove buildings. And I say people were not removing buildings willy-nilly in my area before the plan change, and I don't think owners demolish on a whim. Owners in my area are required to rebuild a home in the spirit of the neighbourhood. Template 3.16 is a change from the original notified plan change. So now it reads, any application for demolition or relocation of a contributory building or home in an RHA, as long as it's not a heritage item, shall not be limited or publicly notified. So that doesn't help me because my home has been classified as defining. But just because the council have decided that a resource consent to demolish a contributory home does not need to be notified, it doesn't mean that the owner does not have to go to considerable unnecessary expense and effort, i.e. jump through hoops, not to mention the stress, to obtain the resource consent to demolish. Although council can't unreasonably refuse demolition, it is still totally up to the council to grant or refuse. Then the last thing that I picked out of there was 8.4.1 was a rejection of submissions 135.2 and 103.7. That was Melissa Farland. I supported those. But at the end of Dr. McEwen's reasons for rejecting the submission, she states that my area, the CPT, North St Albans, has a high level of integrity. And I'd like to point out that I would attribute that 100%, this high level of integrity, to the fact that the character area rules are working well and have done so for a very long time. The more I read the 42A, the more disheartened I became. I get the feeling that council seem to think if they don't introduce RHAs to stop us, we'll set about degrading and ruining our areas over time. 6.1.29, death by 1,000 cuts. So that was my 42A experience. And so number 2, I read parts of other reports that I found online, some statements of evidence, and they were all fairly difficult reading, above my owner/resident grade, really. But, just one thing I wanted to point out is that I couldn't work out how one might place an estimated monetary value on these protected properties in terms of public good. And I wasn't sure how the introduction of RHAs might have an impact on tourism either. That's the side. Number 3, in preparation for this hearing, I read other further submissions from submitters in my area and other proposed RHAs that seek the same or similar outcome from the IHP process. I saddened to find that there are others in a similar position as myself, but glad that I'm not alone. I was happy to find so many submissions and further submissions that reject RHAs and all associated rules and regulations.
If you are going to have a conversation,
hopefully I'm sort of 3/4 of the way through, sorry. So I'm here today to oppose the introduction of new RHAs in all of Christchurch, but in particular, the Church Property Trustees of North St Albans. I believe that the special character area overlay rules work very well and have done so for many years. We can all see that groups of homes in various areas in all cities and towns, for example, the Californian bungalows in our area, have some similar features, but they also have a lot of differences too. The new RHA status imposed with immediate effect March 2023 is unnecessary, unfair and far too restricting. This new RHA status devalues our homes, and I for one would not and will not ever purchase a property that is tagged heritage in any way, shape or form. I believe this new RHA status will make repairs, renovations and rebuilding more costly, more difficult and possibly impossible. I'm also here to oppose the classification of homes in the RHAs, in particular in my area. I don't see how the council or a heritage consultant can possibly know what state a house is in by just downloading an image from Google or walking or driving by, and then classifying it as defining and contributory. How can the integrity and condition of a home not matter, especially since we're still recovering from the Canterbury earthquake? I'd also like to object to the council having the power to make changes with immediate effect. Clearly, I don't know about council processes, but nor do most residents of Christchurch or New Zealand. How is that even possible, and how is that democratic? I'd like to draw attention to and object to the way in which our council communicate changes and propose changes to the people of Christchurch, in particular the residents most affected by these changes, the lay people, the people who are not in the know. I believe that the results of the submissions process are not a true reflection of what people of Christchurch think or might think if they knew of the plan change and what it means for them. This process is just too complicated, and most people, homeowners, residents, wouldn't know where to start. Christchurch City Council, in fact all councils, should be duty bound to do their best to ensure that all residents are contacted directly and included in the discussion process prior to introducing any new changes that will impact our homes, lives and finances. Most of us don't have an affiliation with a residents association, a neighbourhood association, or have ties with the building industry. I suspect the councils all over New Zealand favour the current processes used to keep residents informed. It must make their jobs a lot easier when there are very few submissions from individuals, residents or homeowners. I feel let down by the council and their favour. You may be thinking that this is all just emotion and actually partly right. Our homes are the centre of our life. We raise our children here. We build our homes here and we have our life savings invested here. We need to know what is going on. We need to be included at the discussion phase. We need to have our say and be listened to before any changes take legal effect. So my area suffered a lot of damage in the Canterbury earthquake. And I know that there are homeowners currently going through the on-sold. I also know of homeowners in my area that have not yet that have yet to revisit their claim as their repairs were unsatisfactory and damage was missed. This might lead to more homes needing to be demolished and rebuilt. It's through no fault of our own that we're in this position, and I believe we are being unfairly treated by council. I'm not exactly sure what constitutes technical evidence as referred to often by council in support of RHAs, but I do think it should include land and building assessment from a geotechnical and engineering perspective. It's difficult to understand why council did not investigate or even consider the ongoing fallout from the Canterbury earthquakes before imposing RHA status on my area. And finally, I urge the council to please delete or reject the RHAs and all associated rules and regulations, including identification and assessment of homes, in particular, for property trustees, Norths and Albans, and let us retain the character area status.
Just a moment. There's a lot for us to just gather our thoughts on. So just give us a sec. Okay.
Yeah. Oh, yes. Thank you. Finished.
Well, firstly, I will say, I mean, this forum, far from perfect, granted, but it's really important and helpful for us to receive the sorts of submissions that you've made today. I mean, the only way that we can get that true representation of an individual perspective is through the likes of yourself and others who we're hearing, particularly today, taking the time and the effort, and I understand the challenges that can create to come and do that for us. So, heartfelt appreciation. I know the opportunities there in the law to allow people to do that. That's easily said. It's actually a real challenge to do so. So I commend you on that. That's not specific to you. That's a comment generically to everyone in the room.
Absolutely.
What I'm saying, and this doesn't, I don't want to diminish anything you've said to us, but there are very apparent limitations to what we can and can't do in response to what we hear by way of submissions. I don't know if you've heard about it, but there was a lot of conversation, and often it's a really legalistic conversation around the scope, what we refer to as scope. So how far we can go as decision makers, or recommending the council as decision maker, is bound by certain things, what the plan change proposed and what people ask in relation to it, set some parameters around what we do. You're not alone. We've heard it from others where there's comments being made to us about engagement or understanding or level of information exchange or communication, understanding, interpretation. Those are matters that we are unable to influence, partly because they're either happened or they haven't happened, or they're beyond the bounds, for example, of what the scope of what we're allowed to do or consider can reach. I'm not making any judgments around what you're saying about those things. I just want you to be aware that there are parameters within which we have to operate. And sorry, that goes with the same comment I made earlier about your ability or anyone else's ability to participate in the process. I'm not trying to be dismissive of anybody, but we are bound by those. The integrity of the process is important. So we have no choice. I don't know, you might have come to an amicable resolution. We'll come to that shortly. But that's the first point I'd make. The second is there's some things around your process that you're involved with your own resource consent. and the challenges you're confronted with that and where that sits procedurally. Again, that's not a matter that we can address through this process. So I don't want to diminish the significance of that for you and your pursuit of trying to get an outcome. Just be appreciative of the fact that we are constrained in that regard. And our recommendation decision will probably, I can't speak for my fellow commissioners, but be at pains to make those points, particularly when we're dealing with a whole range of lay people who may not understand those parameters or where the start and finish of our opportunity or scope lies. Right? We'll endeavour to do that in our decision, but I wanted to make that point because a number of the things that you've talked about push beyond those boundaries. Okay. I don't have any particular questions other than making those points to you. I don't know if other questions.
I don't think I do. It's clear, and you've gone through the history in some detail. Yeah.
I know it was long, but I was just using my journey as a build-up to what I was asking.
Yeah, and what I'm telling you is we don't hear that unless we tap into the people that are experiencing those things. We can hear of the theory and we can understand that those things might exist, but it's really valuable to hear it firsthand. Now, it may not make your journey any easier. Okay, appreciate that, but it's very helpful for us.
And it's highly appreciated how you've battled your way through and come to sit here in front of us today. So that's very.
And if we've added to your woe by making you wait in a hot room, I apologise for that. But we've all suffered that a little bit. And now you're free to go.
Thank you. Thank goodness the shop was open, I say.
Yeah.
Okay.
Well,
Thank you.
Thank you very much.
Thank you.
Just want to do a bit of a stock take on timing. From my reckoning, we've got 3 individuals. Now I don't know how to pronounce your surname, so I'm not going to try. You're going to tell me. That's partially helpful. You're scheduled to present, and how long might you take?
I reckon we'll be done and dusted in about 1 minute.
Okay.
I think you've given me 5.
Now, I'm conscious that Civic Trust are also patiently waiting. And I don't know if you've come to a situation of accommodating. Yeah, okay. And the last party who's no longer here. Oh, yes, he is. Sorry, you, sir. And I got no idea how to pronounce your surname.
Hello, Snoep.
Yeah. How are you placed for timing?
Look, it only takes 5 minutes to read out what I've got. I
Okay.
think you've got all the information already.
Yes. So 5 minutes from you, a few minutes from you.
10 minutes.
Okay, I'm going to ask you to offer up order of events here. Are you needing to go early, later?
Yeah.
You can wait.
Yes.
I'm going to go with you first because you're first on my list. And then I'm going to go to you, sir, and then I'm going to come to the Civic Trust. All right? Very good.
Excellent. My turn.
It is.
Moment in the spotlight. Have you got what I wrote? Feasibility, or would you like copies?
We've got that.
Yeah, that's all I've got.
Okay, that's fine. I think we've all got that. And we've got the submission material in the back here.
I'm pretty sure. I think. I mean, shall I just talk for a minute?
Sorry, just give us a moment.
Yeah, you've got a speak copy of it.
I've got 9 specs.
Oh, of course, you're the total Oh, and I'm not. I should say, I'm participating in this part of the either in here. I can leave the table, or I can sit here and not participate. But I'm not going to because I have some connections with Charles Mistake. I'm not going to be involved in the determination of this issue.
One with me if you stay.
It's easy. We don't banish Commissioner Caldwell from the outskirts. You might want to. Feel free. But be assured he's not going to participate in the deliberation or decision making.
Judy locks if I talk to him.
Don't make eye contact.
I'll turn around.
Look, I won't read this. If you've read it already, there's no point. Let's just go straight to questions. But
No, we haven't read this.
Oh, you haven't read it?
No, we've got the background material, but we haven't read this specific. So if you want to take us.
You want me to read it out? Shall I? Well, look, I reckon I'll just summarise it.
Okay.
Let's read it.
We will read it. Yeah.
Everyone else can read it at their leisure. I mean, I was just thinking, listening to the previous submitter, that we've got the opposite problem, which is that we completely agree with everything Councillor proposing. We're thrilled. We would love the rest of the batches to be heritage listed. The batches We see them as being really dear to the people of Christchurch, and we're well aware of their kind of public impact, both where they sit in the landscape between the beach and the hill, but also where they sit in people's minds and hearts. Iconic part of the bay, and also of maybe the cultural landscape of Christchurch, one way or another. So you're probably aware that a few of the batches have got Heritage New Zealand listing already, and then some of the batches got council heritage listing in the 2016 plan. And it was really just a time and resource issue that all of them weren't listed at that time. And so there's been quite a lot of work done since, and now those S32 reports are before you. So yeah, look, we would love to see those batches listed.
Lovely. Thank you.
I thought
I've got some questions just to really around my understanding. I mean, I've lived in Christchurch for a number of years, quite a number of years. And like I suspect most residents of Christchurch have a general awareness, but I've never experienced the batches as a resident. I don't live there. I've never been. Are you permanently resident there? No. So what's your association with the batches, other than the association with the association?
Our family bought a batch about 10 years ago, an earthquake damaged batch.
Subject to all the qualifiers around the council.
Yeah, and bought. So really, we kind of prefer to say that our family caretake a batch, because obviously we don't own the land. We've got a licence for that at the moment, but the responsibility for maintenance and upkeep lies with us.
And given circumstances of occupation that exist out there, what was your perspective on entering into that arrangement? That's a very open question, but
yeah,
it's not unencumbered. I mean, there's limitations of what you can, and potentially the security, etc.
Yeah, and there's a lot to that. There's probably no simple answer.
Yeah,
but yeah, I mean, I had a vague understanding that since the first licences were issued in, I think, 1911, correct me if I'm wrong, Brent might be more up on this than me, but something like that.
True, but yeah, it's been a while.
It's been a while. So the first licences were issued and then they expired, and then there was a lot of, Brent, you're going to agree with me or disagree with me on this because Brent's a bit an expert on it all, but there was a lot of toing and froing from the council and other parts of the Environment Court were involved as to whether the batches should stay or go. It swung completely from one to the other over the years.
Yeah.
And the most recent thing is that in 2016, I think, most of the batches were offered licences, not the ones with natural hazards. Yes.
Yeah. But all that was visible to you. That history was apparent. You made your family made those choices.
Yeah. So I'm an architect. There's a few architects own batches, and I think I'm not sure why that is. We talk and laugh about it quite a lot. I think it's because they're the antithesis of what we do professionally. So you know, there's so much that's really special about them. They're tiny. They range from about, I don't know, 25 to maybe 50 square metres, something like that. I haven't even been in all of them, and we've been there part of it 10 years. They're DIY. They've been kind of added onto. They're not. There's nothing controlled or designed about any of them really, and they exist communally. They've never been turned into mansions. They're worth nothing. In fact, we now can't sell them as a condition of the lease, so we're stuck with them. Yeah, it's just the opposite of how we live usually. We own the land, and I know that's a big tension that you guys have been discussing. How much right do you have with what's on that land to do whatever you like versus the public good of that land or how it contributes?
Right, it's a very polarising topic. I suppose Taylor's mistake has got its own uniquenesses around that, in that bigger context of perhaps trade-offs between public and private good.
Yeah, that, and it's always been quite communal. The land's never been owned, although having said that, we do as a group now own 80 hectares in the rest of the valley. So we own much of the rest of the valley directly behind the batches, but we don't own the land that the batches sit on. We own the structures. only. So it's pretty interesting. You can't do a lot with that. You've got a huge public obligation with that, including spending a lot of time fighting against existential threats in the 10 years that I've been part of it, and in the maybe 100 years before that they've existed. So they're a passion project. They're certainly not a wise financial investment, that's for sure. But our kids are all part of the Surf Lifesaving Club. They're all lifeguards. It's been the most amazing thing to have as part of our lives for our friends and family.
Thank you. I don't have anything further.
Any questions from the silent commission?
Even if he might have in his head, he's not asking. But thank you very much.
You want to know how big the surf is, I think.
Thanks very much.
Thank you very much. Thank you for tuning in to the last meeting.
What did I say? I can't remember what I offered. The next, a few minutes. You said you would like a few minutes. Have you got that? Have you got copies of that for us, or just the one?
I sent it last week to the council.
Oh, okay.
You should have those.
Just bear with us. Do we have those?
They're on the website. I don't have a hard copy for you. You should.
Oh, sorry. What are we talking? Are we talking about the summary statement submission? Summary of the submission or the submission?
Summary.
You've got a full
We've got the full set of
earlier on.
submissions. Yeah.
I don't know if we have a summary now.
Last week, just another farm.
I don't know if we've received those hard copy. That's fine. Happy for you to present them to us so we can get a copy of you. That will be fine.
Sure, no, you can have that.
If you just need those to
I've
read.
got a copy at home, so you can have this.
Yeah.
Okay?
Yeah, that's fine. So have a seat. I'm rushing you through here. Over to you. Thank you.
Allow me to make this submission to you. I've kept it short, as you asked me to do. I'll just run through this. Number one, plan change 13, in my opinion, does not support necessary law under the Sort of Management Act, general law, or Parliament's instruction about the location of batches offend the function and purpose of a public road. And number two, I remind from the onset that the council has stopped from issuing licenses to 14 unscheduled batches required to be removed under a rule set by the Environment Court in decision C58 in 2003. My rights to this decision are protected. I find the use of the Heritage Order to sideline this consent memorandum as a means to keep the batches abhorrent. It is contrary to natural justice, precisely and effectiveness of the order. It cannot maintain the future authenticity. Existing use rights will see to that. At 3, the history of the batches tails mistake has been thoroughly canvassed up to 2002 by various commissioners and the Environment Court in 2002. There is nothing new in Plan Change 13 that has not already been considered in detail by experts at that time. At 4, that history has recently been reviewed by the Independent Hearing Panel in 2016 and Decision 52 of the Proposed District Plan of 2015. At 5, occupation of public recreation land on the coastline constitutes a significant issue that is of natural importance, recognised under Section 6, according to the Independent Hearing Panel. At 6, Section 6D, public access, and Section 6F, heritage protection, are not mutually inclusive with the physical presence of the batches located on public land and their interference with public access. The Independent Hearing Panel has determined that it's more important with regard to the public access under Section 6D. I rely on the determination made by the Independent Hearing Panel in Decision 52. The particular finding by the independent hearing panel as a matter as of natural significance as section 16, resulting in a policy 18229 of the district plan that by improving recreational public access and or restoration of the natural character value of the coastline. At 8, the council under section 84(1) is obliged to observe that policy 18229. At 9, the heritage rule proposed in Plan Change 13 will not prevent the batch owners through their existing use rights, their ability to alter, replace or enlarge the batches at will under section 10(1)(a)(2). This seems to defeat the purpose of the order in maintaining authenticity of the item. Finally, at 10, I've read the section 32 evaluation of the provision of the batches listed as heritage items. In my assessment, it falls short of the qualifying standards. My reasons are set down in some detail in part 2 of my statement already in your possession. Thank you.
Let me just thank you.
Really advise you on so profoundly deaf, so I have some difficulties actually understanding you. And
well, here's me sitting here without my hearing aids in, and you being profoundly deaf. This conversation could go on for some time.
I'm too old for that. I just would like this, leave this with you some photographs that might help you in your site visit.
We've been to the site, so we've been out to the batches. Now that's not to, we have already been there.
You've been out anyway.
But we're happy to take these. Do you want them returned?
No.
We'll look at those in the context of your submission. I just had one question, and you may be question to my colleague. But if I'm understanding you correctly, you're suggesting or proposing that the heritage provisions contravene or undermine or conflict with the independent hearings panel decision on the district plan review in 2016. And I think you said also an earlier Environment Court decision of, I think you said 2003, I might have that date wrong, but have I got that right, that you see a conflict with those earlier judgments based on?
Basically, it has been sidelined through the heritage proposal.
Yes.
Of things that are still outstanding that the council doesn't want to address.
Yes.
Which are the Zen memorandum of 2003 Environment Court. And the other one is really the policy that has been created by the independent hearing panel in 2016.
Yeah. No, okay. So well, I thought I heard you right.
That's basically.
Yeah. I don't know those documents off the top of my head. I'm aware that they exist, but I haven't read them. We haven't read them. I don't think most recently we will do, but I just wanted to make sure that I had heard that right. That's the premise of what you were saying, is there's an inconsistency or a conflict or some something of that ilk with those earlier judgments. My only other question is, do you? What's your association with the batches? So you're not a batch owner. You don't live there, or do you?
No, I've got no. I've got association in terms of knowing the people.
Yes.
Particularly older ones are no longer alive.
Yes.
I'm just will bring being the same. Anyway, so as I said, I sort of been associated with Taylor Mistake for 70 years.
Yes.
So my knowledge and history is possibly as good as anybody else. That's about.
Look, I'm not. Don't take that wrong. Just you don't have to be a resident of the batches to have a.
Happy to live there as well, which makes it, greater interest to me.
Yeah.
To what's really happening down there, and I like to see it cleaned up.
Thank you. I don't have any questions.
No, I don't have any questions. The only one was told that I wasn't aware of the 2003 Environment Court decision, but we will follow up on it and read what the decisions were there to figure out exactly where the discrepancies lie.
I can address that in the closing.
Yeah, that'd be helpful. I mean, it'd be useful for us to look at it. If we could traverse that, that'd be good.
But in broad terms, the 2003 decision was a decision on appropriate provisions in the Banks Peninsula District Plan.
Yeah.
And that plan doesn't exist anymore.
Our suspicions that were out there, but it'd be useful to have that context explained to us.
Yeah.
All right. Thank you for that. We'll keep that. We'll copy it. Again, thank you for your patience and thank you for your time. Thank you very much.
Thank you.
Thank you. I was going to say lucky last, but perhaps we did the wrong impression. Projects like this, but Civic trust.
We'll take it anyway.
We get you to.
We probably have one supervisor. But yeah, that is a topic that's good.
I was happy with one set of those.
But he doesn't do it.
Yeah. So yes.
I prematurely to information. We got a presentation summary. Yes, we do. Sorry, give me a moment.
Hello. And thank you for hearing us today. We got there in the end. No, that's fine. It's a process that we go through. My name's Hamish Gilchrist, as you know, I'm the chair of Civic Trust, Christchurch Trust, and this is Joll, and she's a.
Sorry, you're certain.
I did more DINGWALL and for me. And I'm a board.
Okay.
Okay, so I'll.
Yeah, so we got this. I don't know what your intentions are.
Well, I'm just going to read through and you can follow with me. I've just got the timeline so we don't go over 10 minutes.
Take your time. Yeah.
No, that's fine. Thank you very much.
In 3 hours' time, I might pull you up.
Okay, no, thank you. So in the matter of the Resource Management Act, proposed plan change 13, heritage to the Christchurch district. Canterbury heritage license setting 9 Desmond heritage license 463, heritage setting 203. The Christchurch Civic Trust, having observed this PC 13 hearing, that has a good sort of understanding of opening line of the necessity for this PC 13 process. And in respect to the heritage listing and setting of Desbury House in the Christchurch District Plan, given the press release on the 6th of June 2025 of the Minister responsible for RMA reform, the Honourable Chris Bishop, relating to the decision-making process for Desbury House. Furthermore, before the Minister's press release, the Trust had raised with the Minister the relevant matter of validity of the alternative recommendation of the Christchurch City Council to the Minister for the renewal of heritage listing and setting of Desbury House. The historical context is set out below, so following along with this. So starting with the latest press release of the Minister concerned the alternative recommendations referred to him by the Council for a final decision. The Council having rejected certain recommendations of the Independent Hearings Panel, including that for Desbury House, the Minister stated in his release, I have carefully considered this matter and taken extensive advice from officials the law requires that it only consider matters that the IHP could have taken into account in making its recommendations. I've skipped that italicized bit, I think. I have not made decisions on 3 recommendations relating to Daresbury's Ontario I intend to consider these recommendations once the council has decided on the zoning of these areas. The council may refer these decisions to me again ahead of deciding on the balance of plan change 14. Similarly in the council, please note I'm not making decisions, and a quote from him, please note I'm not making decisions on the referred recommendations relating to Daresbury House, Antonio Hall, Pico residential character area at this time. This is because the council has not yet made decisions on zoning of these areas. I intend to consider these 3 referred recommendations once the council has decided on the zoning of these areas. The council may refer these decisions to me again ahead of deciding on the balance of plan change 14. So going back, the matter of the retention of the heritage listing and setting of the Christchurch district plan has been considered by the IHP hearings on the council's intensification planning action and change 14. Having considered the extensive evidence and submissions, the IHP subsequently recommended to council the rejection of Daresbury Limited project, seeking the removal of heritage protection for 9 Daresbury Lane. However, on the 2nd of December 2024, notwithstanding the fact that the council had been informed that Daresbury House was outside a Policy 3 area and no decision regarding its heritage listing was required until the 12th of December 2025, the council resolved to reject the IHP's recommendation. Council subsequently resolved to accept the council's proposed alternative recommendation that the Daresbury heritage listing and associated setting be removed. Council's alternative recommendation was referred to the Minister for a final decision.
Councillors, would you mind if I just intervene for one very brief moment to raise a matter with you? I've read through what Mr. Gilchrist sent up to page 5, and there isn't a single paragraph in that which is relevant to your decision making on PC 13. I just want to point that out, and it's in your hands as to obviously whether you wish to hear this.
I haven't read through it. I agree with you up to this point. It's a chronology of what's happened in the past. What are you saying? That there's nothing in relation to this that has a bearing on the submission?
Yes, so the written document I see in front of me is about the council's decision making on PC 14.
Yes.
And the decision the minister has made on PC 14.
Yes.
Your decision is not in relation to those matters, and those matters are irrelevant to the decision that you're here to make in relation to appropriate provisions in the district plan.
Okay, so you're saying that in relation to what's in front of us, but nothing in relation to the Civic Trust submission. You're not questioning that.
I'm not questioning their submission at all.
Do you understand what we've been told?
Still under consideration was how much the panel would be taking into account the council's alternative recommendation. The fact that the council had rejected the previous independent, and would be aware of the council's alternative recommendation.
We're certainly aware.
And the basis on and what the council relied on when making that alternative recommendation. And we're calling into question the validity because the council relied on a statement from a councillor, and it was information which had not been previously provided to the IHP.
We're aware of that. We've been given that context around what information exists documenting the council decision to reject the independent series panel's recommendation.
Yes. And the validity of what the council.
Well, that's a judgment call for us to make as to whether that gives us sufficient reason to make inform our decisions around PC 13. All right. What Mr. is suggesting is that unless what you're wanting to present to us today has relevance to what we can decide on PC 13, it becomes rather peripheral. Well, in his words, that's correctly so irrelevant.
Yes.
Now, that's not undermining what you said in your submission on PC13. That's still valid. No one's questioning that. The question put is, and he said the advantage of trawling ahead, I haven't, is whether this is actually helping that cause because it may be outside, in his view, outside the ambit of what we could consider.
Right. Well,
If I could just
yes.
add, I guess, what we've got the resolution obviously from council with the recommendations, and I've had some information advising that was made, but it's not for us. The reasons the council made that decision are irrelevant from our perspective, because we will consider, because the matters before us, we will consider the evidence that we hear and have heard, and we'll go our site visit and all of those sorts of matters, and then we will make our recommendation to council. So these are I mean, we're not here to do a de facto review of the council's decision.
It's relevant context because we know it's happened.
Yeah.
And there's documentation of what's happened. But correctly, we're charged with making the decision on what PC13 recommends now, if you like, irrespective of the rationale for previous decision making. And we're entitled to make form our views on whatever decision or recommendation we make back to the council on the evidence we received.
So we didn't know what weight.
Yes, I understand. Yeah.
Yes.
It's in the mix. It's contextual. We understand it supports previous actions, but we have full license, if you like, to make our own judgments around what sits before us in respect to Canterbury or any other matter on PC13 on the evidence we receive.
Okay. That's why we have independent commissioners making that recommendation.
The quirk to that is, of course, is we are decision-making authority. We are simply making recommendations back to the council on the plan change for it to decide on. So we're not the ultimate arbitrator, if you like, in terms of the submissions. It is a recommendation role. Now that will flip back to the council who have that responsibility.
As you'll see from what's here, the minister is well aware of the.
Yep, no, we're absolutely aware of the minister's letter and the decisions recently taken and previous ones. So I don't feel we need to go over that history anymore. And I have some sympathy with what Mr. Pizzik's saying. If that's all this submission is telling us, we can read it and we're aware of it. It doesn't change our role and responsibility in respect to PC13. So in terms of your question about relative weight,
Of the health.
Yes.
And I understand that. But be assured, if you like, it's not starting afresh with our eyes over that. That's part of the context that gets us to where we are. But we have the opportunity or the responsibility to make recommendations based on what PC13 says and what we hear in evidence in relation to it.
Yes, I suppose so. Having drawn it to the minister's attention, this process that we were examining, he still hasn't made any decision on that, and so we sort of the question remains: if obviously you're got an independence for your own panel here, and are able to make those recommendations. We're just going to end up in the same place where the minister hasn't made a decision on the first reading or panel hearing, and potentially, depending on what you recommend back to council, we're going to end up with two decisions to be made, sort of thing. Do you see what I mean?
Yeah, I hear what you're saying.
Yeah.
In a roundabout way, you're right. But we're not in a position to change that. You know what I mean? We're in a process that potentially what lies ahead is a whole lot of further decision making, which none of us can speculate on, other than we know that it's still to happen. Now, I don't know if you were here at the very beginning of the hearing at the start of yesterday, but Mr. Pizzey set out, guided us, if you like, in respect of what all that context means and what our responsibility is and what it isn't. So if you haven't had the opportunity to consider that may be informative in terms of you trying to get your head around that tension. We can direct you to that, but so there is some guidance, if you like, in that respect for us.
Yes.
I don't want to trouble you with presenting information that is, as Mr. Pizzey says, outside of our ambit. We're happy to receive it and consider it as we think and make our own judgments about what we're hearing. But if he's right, it has little relevance, if any.
Well,
I haven't read it. I'm relying on him being reading ahead, which he's,
It's really the first 5 pages, the rest are attachments.
yeah, no, okay,
yes, that's right.
yeah, no, get that.
So if you would you like us to carry on? Or
Perhaps,
yeah.
I want you to tell us, if having heard what you've heard and what you've read since you put in your submission, if there's anything that's changed in your view around what the trust was submitting on originally, first and foremost. So you've heard of some changes recommended through the Section 42A report, for example. Be interested in your thoughts if you have any on those.
Well, I was wondering, perhaps not so much on that, but I was just wondering about the minister's decision to sort of hold back with his decisions regarding zoning, because I mean, this hearing hasn't, I've seen, dealt with zoning.
And it doesn't, and it won't.
No.
Okay, that's
So
outside of our ambit.
Yeah.
But we will make a decision on the respect of what Plan Change 13 is saying. We will make a recommendation to the council for a decision on what Plan Change 13 is saying about Daresbury, if that's your particular interest.
If you talk about it being changed at Section 42A, or Section 42, whatever report,
Yes.
I mean, the trust point of view, we thought, well, everything was done and dusted through the earlier PCT 14 addressing Daresbury. And then to hear that that was now PC 13, which is going to be considering Daresbury again, that's why we only sort of caught up with the
This piqued our interest.
Yeah.
How do we arrive at the situation? If you can understand our point of view there.
Yeah, I do.
Yeah.
So your question about Section 42 is, well, obviously there's been some water under the bridge that we're not aware of, and
No, what I'm referring to there, it's through the process of considering what is relevant to Plan Change 13, includes Daresbury, but a whole lot of other things. We've had some suggestions by the council advisors and officers of what they would recommend to us as possible changes to what was notified on Plan Change 13. So that's new information, if you like, post when PC 13 was first notified and when you made your submission. You may have a view on whether you're happy or unhappy with some of those recommendations relevant to what you submitted on. I don't know. No, okay. That would be helpful to know because that's occurred since your submission was made. What may happen in relation to PC 14's determinations by the minister in the future, we can't influence, nor can we speculate on or say. You are right. There is conceivably we end up with a trail of decision making between now and when that happens. That might not all be aligned.
we are but late.
Yeah, no, I'm empathetic. It's empathetic in every respect. But hopefully what I'm trying to do is set that context so that you understand that we are confronted with PC 13, notwithstanding what may or may not happen down the track. And we can't and won't be deferring our decision on PC 13 because there's some unresolved matter that sits out there in the future.
Oh, thank you.
Well, thank you very much for listening to us. And,
But you've filed a very comprehensive submission. And I may have some questions of clarification in relation to that if you've got that in front of you, because that.
Oh yes.
Yeah,
that submission addresses.
Don't get me wrong. The only issue is not what may or may not happen around PC 14. You've got a submission in its own right.
Yeah,
that's right. Yes, we do. Yeah. Thank you.
So, and it is a comprehensive submission. Okay, so for example, you've addressed the on page 3 of the submission. It says P24. You address Infield Lodge, for example, and you've got the commentary there in terms of its importance. So
was that an original? Original submission. So this is what we've just presented today, which relates to the council's decision process when making the alternative recommendation, and the fact that it took into account information which hadn't been provided to the IHP.
You've lost me.
So you're referring to
our original
submission.
Yes.
That submission raises a number of issues which aren't if you like, contaminated by the matters we've just discussed as to our ability to address, in terms of the council's decision regarding Daresbury.
We've got a bit of a disadvantage there. I don't have that initial submission.
Well, I mean, yeah, I'm sure it's the right one.
So
It's
we've got a replacement of chairman since.
Yes.
12th of May 2023.
No, he won't be able to.
Okay, so
Well, I mean, it's comprehensive and it addresses the matters. It would be helpful to be able to discuss it, but I don't think it's critical. And if you're not in a position to do that,
Because this was something that the previous one, who was on the Canterbury Historic Places, and he had particular specialised knowledge and prepared that submission, and he's no longer chair. So we're not in a position to add anything or comment.
where that leaves us, and it's not necessarily a problem, is that all we can consider in respect of your submission is what we've received previously
Right,
through.
Okay.
Right.
and it's as I say, it's comprehensive. It's addressed some of the changes. It's addressed the Princess Margaret Hospital site. It's addressed the
That's right.
Inglefield Lodge,
Sort of weird.
Hector Park.
What is in it, but not.
You might have heard some of those things being talked about, some of those things, some of those locations being described or discussed in other submissions.
That's right. Yeah.
And I'm as I say, it's not like some submissions we get to just reject or accept with very limited reasoning. This has quite a detail on this. It almost reads like a brief of evidence, if you like, that somebody would present to us.
That's a helpful thing. That comprehensiveness and fullness is.
Given that he had a lot of expertise.
Yes, in front of me, and probably you as well.
Yes.
Ross Gray.
Yes, yeah. No. I don't want you to be prejudiced by it, and I'm not trying to. But it may well be that you may want to have a read of that again, and not necessarily come back and address us on it tomorrow. But you might want to file something, and I think would be willing to accept if there was anything that you wanted to comment on in here, and by way of expansion of the points that you've raised in your submissions.
Okay.
I don't know whether you have
It's not a requirement if you take that opportunity.
The health of the chairman wouldn't.
No.
He wouldn't be able to do it.
No. That's fine. We're just I'm just saying that if you wish to lodge something, I mean, because as you would have heard, the chair is away. And so we're going to have time.
Time is your friend.
Okay.
So if you feel that, I mean, you're at a slight disadvantage in the sense that you're not across the submission of the way if you were instrumental in its preparation. We don't want you to be disadvantaged by that reality. When we've got some time for you to be able to take a more considered view on that submission.
So we can do something else.
It's not a fresh submission.
No, but
if there was anything commenting on something in here, then I think that would be we're prepared to consider that. We can consider whether it's shouldn't really once we get it, if you like.
Are you asking in relation to Inglefield and?
No. If there's anything in this that you wish to expand on, but subject to, just what you would say if you were taking us through the submission, you'd say, for example, Princess Margaret Hospital is a big building, it's got the blah blah blah. That's all I'm saying. I'm just saying that we would give you that opportunity. Mr. Pissy, you wouldn't have any objections to that. And that because you've been, the minister's decision and the council's decision have been a bit of a distraction in some ways, not at all downplaying their importance, but we've talked about what they're not relevant to us. So that's why I think it's appropriate if you wish to have a look at this if there's anything in there that you want to provide some brief expansion on, explanation, then that would be,
Okay, and we could do that tomorrow or?
No, we can do that.
By reason to prove.
Yeah.
Well, we could make it, we could issue a direction, but I would say within 10 working days or.
Yeah, take a week or two.
Okay.
Yeah.
Right, so, as you
And
say,
there's no compulsion to do this.
No, you don't.
And the other dimension is if you've heard things, I appreciate you've been sitting here listening to quite a lot of conversation, and some of that may have relevance to what your submission originally raised as a topic or a matter. So if you feel you want to comment further in light of what you've heard from others on matters that aren't relevant to your submission, then do so. But again, no compulsion to do it.
nothing issue.
And if you do that within a week or two, let's say two, that would be appreciated.
Good. Okay, well, thanks very much for that allowance. Yeah, I think Mr. Pizzy has pointed out a good point, so thanks for that. And so thanks for your time this afternoon.
Again, like everybody today, thank you for your patience, tolerance, and appreciate the effort and time you've taken to be with us.
Well, no, thanks for allowing us. Thank you.
Thank you.
Thank you.
Thank you.
Now, where do we land with you?
Just say just about 2 minutes.
Well, only if you're doing it in support of the Civic Trust.
Yes, I am.
And they're happy for that to happen?
I don't know. Yeah, we haven't heard what Jocelyn wants to say.
No, well, they've got to say.
And I'm sorry that you can't. And the reason I say that is because
The whole day, I'm sorry, but I've spent the whole day here. I was told that I could get the picture that nobody's seen of Desbury.
you can't. Sorry, I appreciate the disappointment, but we are bound by what the submissions. Those who make submissions and those who have made further submissions. It's a non-negotiable for us. It's not me making these rules here. That sets the parameters. If somebody's misleaded you on whether you can present to us today, I apologise for that. I don't know if that's happened. Yes, okay.
And also, I have been 30 years with Civic Trust.
Yeah, we'll give us some
The little,
What I would encourage you to do, you might have heard what we just suggested.
all I really wanted to say, and I may as well say the two things.
You
First,
can't, sorry, you cannot say it.
I won't say it then.
But you might talk to the Civic Trust representatives.
Oh,
and
you
whether
won't speak to me.
Okay.
No.
At that point, we'll adjourn now rather than close here. And unless you want to give us, I'm sorry, I'm preempting your closing remarks or the opportunity to pick up at the end. I think we've gone through all the submitters' presentations and the leases with you. And as we've discussed, the option to present your closing submission to us in writing is attractive to us.
Yes, that's me, Commissioner.
And I just wanted to talk about timeframes in respect.
Yes.
Your thoughts?
Timeframes for a number of things. First one is if the panel wish to commission or ask for further reports, as you're entitled to do so. Now would be the time if you wish to set your minds to that.
Yeah. We don't know at this point, frankly, but we're gonna take tomorrow. I'm around tomorrow. We're all here, so we're gonna spend some time in the morning capturing our thinking around that. Now, correct me if I'm wrong, but nothing immediately springs to mind. We've asked for certain things.
Yes.
The wiring diagram, the T diagram from Mr. Dixon, for example. We'll expect to receive those. Yes. But in terms of something we haven't raised in the context of the hearing, I'm not aware of any, but we can do that. We can have that conversation with the board.
Yes. Yeah. Thank you. And so the two things for the council's reply, one is the right wiring diagram and the other one is the right of reply itself. They may as well be at the same time unless you want to see the wiring diagram first. Options I would for your consideration, commissioners. I'm on leave for 1 week from the 7th of July. So
starting or finishing?
Starting
7th of July for a week.
for a week. If it suits you, commissioners, the dates would be either Friday the 4th or Friday the 18th.
That's fine.
18th. Thank you.
So again, if we get the wiring diagram so called, that's fine. So that we need that early. That's what is there anything else that we were thinking of? We've got Dr. McEwen's update pages.
Yes.
There's various copies of information that where I've asked for copies to be provided. I'm pretty sure we haven't got all of those yet, but we're happy to have those just emailed through to us, just for our records. And there's no particular hurry for that. But you know, the next few days, if you could get us copies of what we've asked for, that would be great. The other thing I've asked for is, if it's possible, just a notification of who was on the live stream through both days 1 and 2. Please. Thanks very much.
No, we might have something tomorrow to raise, which we could raise.
Yeah. You around tomorrow?
Yes.
Yeah. As I say, we're going to gather ourselves in the morning and make use of tomorrow, which we have available to us to advance our thinking. So there may be things that come out of that first thing, but if there are, we'll perhaps contact you or contact through Darren directly as to what those requirements were.
Thank you.
We're down to who we started with, I think. Well done. Look, just from my perspective, we'll adjourn to the hearing at this point. We'll receive that information in due course. It's very likely that we will want to take site visits for Dearsbury and Antonio Hall and make those arrangements after I return in late July, and before we, certainly before we conclude our report. That's the only other outstanding matter, which might take some logistical arrangements around how and who gets us to those properties and how far we might safely be able to go. I don't know, but we can work that out closer to the time. Yeah, from my perspective, thank you all for your contribution, not only in the written material but also in participation in the last couple of days. It's been very helpful.
Thank you for the way you vote.
Yeah, not without us, trauma. I'll make my apologies outside of the room, but yeah, a huge amount of material to digest that Gillo produced. So I don't know who I feel for most, us or you. Your part of the journey's coming to an end now, just beginning. Yeah, if we have the need to reach out for any further clarification or information from those contributing to the 42A report, that might be something we can give consideration to in the morning as well. It might come up later in the piece and we'll deal with it as and when. But I'm reluctant to close things until such time as we're pretty reasonably assured we've got all the information and visited those sites, which is likely to be into August.
So the hearing will be open until after you've done those.
It's a convenient opportunity to change our minds. So, all right, thank you very much.
Thank you.